Welcome back to the second part of the Freehold Covenants lecture. At the break, we were discussing what constituted a freehold covenant, and we looked at, just at the end, we considered whether we have a positive or a negative covenant, the difference between the two. And I reiterated that as it relates to a positive covenant, it will generally be where you expend monies. Whereas if you do nothing and you still comply with the covenant, then you're looking at a negative covenant. Now, in freehold covenants, restrictive covenants, we will certainly see that what is in fact enforced will be the negative covenants. The idea then is that when you look at it from a positive, negative standpoint, it is about substance, not form. So if it is in fact a positive covenant, although it is drafted in negative terms, so it requires the person making the promise not to do something so that its form would lead to the conclusion that the effect is him doing something, then of course it's not likely to be enforced. So for example, let's say Mr. Examiner says to you that B is the covenantor buying Whiteacre, and B covenants with A that he will not let the fence fall into disrepair. It sounds like a negative covenant, but imagine what I said in the first segment. If B were to lay in his bed, could he actually fall foul of the covenant? And the short answer is yes. Because if he did nothing, the fence could, in all fairness, fall into disrepair. So it does require that he acts in order for the fence not to fall into disrepair. And that sort of thing, of course, would mean that you're looking at a positive action, and as such, it is important to differentiate them. Now then, let's say the covenantee, who would normally be the original owner of Blackacre, say, sells to the covenantor, the new owner of Whiteacre. Well, when one considers the servient land, which would be Whiteacre, then the idea is that the covenantor is then told that he cannot do something on his land which he has agreed to. And again, just before the break, I was highlighting that landowners are perfectly in their own right to do whatever it is they wish with their land. However, when we consider for a moment, how do you, for example, create a covenant? Well, there are various ways of creating a covenant. Covenants are created in a deed. The document, of course, must comply with Section 52(1) of the Law of Property Act 1925, in which case the document must be signed, witnessed, and delivered as a deed, and it will normally be contained in either a transfer deed or a conveyance. It may be created by a separate deed. Now, the original parties under contract law during the life of the covenant, the original covenantee takes the benefit of the covenant, and the original covenantor the burden. Now, the original covenantee may always enforce any express covenants against the original covenantor. Now, that's pretty straightforward. If you and I make a contract, a covenant, an agreement on the deed that you will not do something, then of course, straightforward, we are in privity of contract. But this is land law, and the point as it relates to freehold covenants is how does a covenant, for example, remain with the land? So if A sells Whiteacre to B, what happens when B wishes to sell Whiteacre to C? Is C liable, as it were? Equally, what happens if A sells Blackacre to D? Will D get the benefit of that original covenant. And again, the idea that I want you to stick with is this whole concept in land law, of course, running with the land and burdens which run with the land and so on, benefit which runs with the land. The first consideration as it relates to enforcement of covenants beyond the parties who are in privity, the first situation I want to take on board is Section 56.1 of the Law of Property Act. And Section 56.1 of the Law of Property Act says that a person may take the benefit of any covenant over or respecting land, although he may not be named as a party to the conveyance or other instrument. So this in effect extends privity of contract to a person who is not a party to the covenant to be able to sue upon it. Now, in the case of Ecclesiastical Commissioners for England's Conveyance, a 1936 case, it was held that the effect of this section was that a person expressed in the conveyance to be one of those, or to be one for whose benefit the covenant was made, was regarded as an original covenantee, even though he had not been a party to the deed. Now, I want to pause here for a moment and let you grasp the significance of Section 56. Whenever you see an examiner giving you a situation which says, let's go back to A and B on Whitaker. If the examiner were to say to you, B is the owner of Whitaker, B covenants with A and the surrounding landowners, that is a Section 56 situation. Because one of the requirements of Section 56 is that the person who is seeking, so the non-party to the covenant, so not the original covenantee, the non-party who is seeking to rely on the covenant, must have been in existence at the time that the covenant was made. So Section 56 does not give successors in title a right to sue. It only gives those who are currently in being at the time of the covenant. So what Section 56 does, let's use a scenario here. If we know that A owns Blackacre and Whitaker, but let's say that adjoining Blackacre and Whitaker is Pinkacre and Blueacre. Let's assume that Blackacre's owner is very good friends with the owners of Pinkacre and Blueacre. And amongst them, they've decided that if anybody is going to buy Whitaker, they don't want the person to build a high-rise apartment building. Well, what A would do when he's selling the land to B would be to say that B would covenant with A and the surrounding landowners. So even though they are not named specifically, we know who they are, owners of Pinkacre and Blueacre who have adjoining properties. But being that they were in being at the time, then Section 56 would apply. So let's assume, for argument's sake, that A then sells the Blackacre to D and A moves away. It doesn't take away from the owner of Pinkacre or Blueacre being able to bring an action against the owner of Whitaker who covenanted to bring an action against B under Section 56. Now, the House of Lords, in a decision in Beswick and Beswick, restricted the interpretation of Section 56. It said it had the effect of reversing the pre-1925 rule, which was that no one but the original named beneficiary or covenantee under a covenant could sue on it. So as I say, when you look at and all the surrounding landowners in our scenario, they would be able to sue on it. Now this was confirmed in the case of Amsprop Trading and Harris Distribution. The current position in relation to Section 56, a person not specifically named in a covenant may sue for the performance of the covenant if the claimant is referred to in the covenant under a generic description. Think of my example there. The covenant is expressed to be made with the third party. Watch the examiner. Did it say B covenants with A and the adjoining landowners? That will mean that it was expressed to be made with them, because it will not be just for his benefit. It must be made with the third party. That the third party existed and was identifiable at the date of the covenant. So Section 56 is one way that a third party can take the benefit. Now, what about the Contract Rights of Third Parties Act 1999? Again, you would have come upon this in contract law. And for contracts made after the 11th of May 2000 under Section 1.1, a third party who is not a party to a contract may, in his own right, enforce a term of that contract if either there's an express term in the contract to that effect, or the term in question purports to confer a benefit on him. Now, in common law and equity, we must consider these two sets of rules which determine whether or not the benefit or burden of a covenant may be enforced. But just to give you an idea as to what we are talking about in relation to the contract rights of third parties, again, an examiner may give you scenario 1, B covenants with A and the surrounding landowners. But what if it says B covenants with A and his successors in title? Now, because it is for the benefit, so B covenants with A, that his successors in title can take the benefit. It means that it is made for their benefit. Remember that with Section 56, it cannot be made for the third party's benefit. It must be made with the third party. So when you look at the Contract Rights of Third Parties Act, especially if the examiner tells you that someone is a successor in title and part of the covenant was that it was to do with the successors in title, then somebody buying, for example, in our scenario, if A sells Blackacre to D, given that D is a successor in title by virtue of his purchase of the property, he can take the benefit of the covenant. Now, as I say, we have to consider the rules under the common law, as well as we have to consider the rules in equity when we look at covenants in order to determine what the rules provide for the separate areas. We will now break, but immediately after the break, we'll go straight into that and certainly continue on in our discussion on freehold covenants.